Hello Legal Eagles, and welcome to a brand new topic, which is private nuisance. If you're looking for Rylands and Fletcher, I'm going to be dealing with that in the follow-up video. So to begin with, a useful quote from a text, Winfield on Tort. It says here that private nuisance is an unlawful interference with a person's use or enjoyment of land or some right over or in connection with it. Now, that's all very well and good, but for the purposes of the exam, we need to break that down into its simplest parts and really look at the components or the elements that the claimant will have to prove. So I'm going to do that now. And as you can see here, the first part is there must be an unreasonable use of land by the defendant. Again, we come across this word quite a lot, don't we, in terms of tort law, the word unreasonable. But this is a topic very much where when the claimant brings a claim, the court will have to make a determination, and they'll do that on the basis of some criteria, which we're going to look at in a minute. Now, this unreasonable use of land has to lead to an indirect interference. Question, I think, why not a direct interference? Because if it was direct, that would involve laws involving trespass and so on, which we're not doing. So I think through the examples we're going to look at, you'll see how the defendant does something and indirectly it leads to the enjoyment of the land being interfered with, the claimant's enjoyment of the land. And of course that's the third part. And just to show as well, in textbooks and so forth, it may refer to this as an unlawful act by the defendant, but remember, we're not dealing with criminal law, this is not crime, so it really simply means unreasonable. Just have a quick sip of water. Oh, I'm not liking these hot nights. Okay, so at this point, I said that the court will look at certain criteria to determine whether or not the claimant's going to be successful with their claim against the defendant. Typically, though not exclusively, it can involve neighbours and disputes between them. So, for example, you can see in the picture there. You may want to pause this video now and just jot down quickly what sort of things or factors would you expect the court to take into account in deciding whether or not the claimant's been successful with their claim. And when you're ready, unpause the video and we'll actually look at the real criteria. Okay, so here we are. Let's see if any of the ones that you actually thought of have come up. So the first factor that the court will look at is the nature of the locality. It simply means that where this particular nuisance is taking place, if it's a residential area, and for example there is a neighbour who sets up a large-scale business with huge transport lorries coming in and out, then that's something that is ill-fitting in a residential area and will clearly be a nuisance. Whereas if it were somewhere in an industrial area or estate, then it wouldn't be. So it really depends on the context of the environment it's set in. And as I say there, cocks crowing will be considered more of an interference than if it were in a rural area. So that's really just getting across that point. Actually, I have to say, years ago, there was a neighbour of mine who kept chickens and other things, which I wouldn't say is particularly typical with neighbours in my area. So every morning I was woken up by a cock crowing. And again, I suppose you could say that would there be a possible claim there? I think possibly there would be. The key case we need to know is Sturgis and Bridgman. Now, remember, the most important thing is knowing the criteria and trying to give a case in support. The facts of the cases aren't the most important thing. Remember, it's always the ratio. I know you know this, but I'm just going to say it again. But there is an interesting quote from this case, which I'm just going to look at here. So it says here that Thesiger, LJ, said that what would be a nuisance in Belgrave Square would not necessarily be so in Bermondsey. And again, it's just really the same point, isn't it? Second criteria the court will look at is the duration of the harm. So the longer the nuisance lasts, the more likely it will be unreasonable. Interestingly there, it says if you come to the nuisance, if the claimant comes to the nuisance, it's not going to be a defence to the defendant. So to give an example, Let's say that somebody moves next to a football club, and so they're aware that on match day the fans within the stadium are quite loud, and then they try to make a claim in nuisance for the fact that the noise is ruining their enjoyment of the land. You could then have a situation where the defendant might say, aha, well, the claimant knew they were moving to a football club. But clearly in that situation, that's not going to be a defence for them. It really then depends on the other criteria being met and whether it is unreasonable. And incidentally, if you're wondering, I think fans in a football ground is not unreasonable. And certainly, unless these matches were being played in the early hours of the morning or something ridiculous like that, which they're not, then the claimant wouldn't have a really successful claim. Interesting case to support this, Crown River Cruises Limited. Why this one is interesting is because if you can in your exam answers, as you sort of discuss and go through this criteria, just make reference to the fact that in this case a 20-minute fireworks display was deemed by the court in that case to be enough to constitute a nuisance. 20 minutes. Now it has to be continuous, but 20 minutes. So therefore, when you look at any problem scenarios, if it does indicate the time, or at least you can do your best guess as to what that time would be, I think that's a really useful bit to add into your answer. Number 3, the sensitivity of the claimant. I think in the law it used to mean something different earlier on, but now the courts simply are looking at this is a test of foreseeability. So would the defendant's interference with the claimant's enjoyment of their land, the nuisance that they're producing, is it foreseeable? And I think we've covered that in previous topics, so it's not something I'm going to touch on too much here. Key case, Robinson and Kilvert, that you want to look at. And again, if you're looking at your textbooks or looking at online resources, it just says here that the claimants stored brown paper on the ground floor of their building. It was in boxes in the basement. The needed conditions to be hot and dry, and the heat in the basement caused the brown paper to dry out, and the claimant sued for that loss. The court decided that the brown paper was particularly delicate, and the heat from the basement would not have dried out normal paper, so in fact there they did not grant any damages to the claimant. Fourthly, the motive or malice of the defendant. Essentially what this means is if you're bringing a claim against somebody, for example your neighbour, and the reason that they are producing the nuisance that they are is because they don't like you or they want to annoy you, then obviously that's going to be held against them in court. All I would say for this is look at problem scenarios where for example, one party is making a claim in nuisance against the other, but let's say, for example, they tried talking to the neighbour first, or they raised a complaint with them or the local authority or somebody, and the neighbour found out and they just decided to commit this nuisance or do it for longer, whatever it might be, then that is obviously going to be held in favour for the claimant. So just very quickly, I'm thinking, if I complain to my neighbour that she keeps playing her music late at night and I'm trying to get to sleep, and she's really miffed, so she decides to just play it even louder and for longer at night because she wants to disturb my sleep, then the court will recognise that here, and that will be held in my favour. Key case here, Hollywood Silver Fox Farm. Again, an old case. Quite an interesting one. I'm just going to turn the page for a second. It says here, the claimant bred mink on the farm. The defendant had a disagreement with the claimant and told his son to shoot his guns near to the property to frighten the animals. Now these silver fox animals would be easily alarmed, quite nervous creatures, so by firing the gun, and many of them I think being bred and they were pregnant, then would miscarry. So that was the malice behind the neighbour deciding to fire their gun, and that is the the damage or loss that the other neighbour, the owner of the farm, suffered. Last part here, not so much a criteria but a question. Social benefit. What if the nuisance that's being produced by the defendant actually has a positive impact on some people? So for example, if I said about that instance where somebody in a residential area sets up a transport company, lorries, whatever it might be, for deliveries, the argument they might make is, well, it benefits the community because I'm making deliveries to them. It also benefits the community because I am employing people, etc. They can obviously offer this to the court in some form of sort of mitigation, but it will not be a complete defence. Simply all I'll say is this: the court could decide to ignore it and go, nope, doesn't matter. Or the court could take it on board and decide, as we'll see a little later, that they may not do anything about it. They may just say yes to the claimant, it's a nuisance, but there's nothing we're going to do. And I think the key case here, I'm not sure if I've got it, is Miller and Jackson, and this was a cricket club. I think here the court recognised that sport, even though there are instances where, you know, it could annoy people in the surrounding area. So for example, I think it was a neighbour who had their garden near to this cricket ground, and cricket balls, again like another case we've done, escaping the ground and caused damage to their property. But the court recognised that sport has social benefit. That is what a cricket club essentially is there for, and so I believe there wasn't actually any sort of injunction offered for the claimant. If you're wondering what injunction means, we will come to that in a second. So yeah, no. I forgot that was going to come up. Right, so example problem scenarios. As ever, we need to be ready for the exam, so I'm going to go through 2 of them with you and then leave the rest for you. So firstly, you move into a house next to a cricket club who have erected a high fence, but 9 balls in 2 years have been hit out of the ground. You feel you cannot use your garden during matches. As I say, you know, the examiner sometimes does scenarios that are quite similar to real cases you've studied, so immediately you should be thinking sort of Miller and Jackson and what was decided there, and we can simply say, you know, I'd set out in my answer the 3 points, I'd go through the criteria, but my conclusion is this: the cricket club would be liable even though you moved into the area and came to the nuisance, as it interferes with your recreational enjoyment. So it is a nuisance, but cricket, as I've said before, is of social benefit or public benefit, and the court will likely not do anything. So you may win your case, but the activity, the nuisance, will still continue. Okay, second one. You live next door to a private property which you believe is a brothel. The sight of scantily clad women taking men into the property offends you, although you cannot hear anything. So you can't say it's the noise that may be coming from said property that is the nuisance, but it is the seeing, you know, the customers, or however you want to put it. Again, going through the criteria, what conclusion can we draw? Well, the people in control of the brothel would be liable for a nuisance. In fact, here it is, of course, as you know, illegal to manage, to run a brothel, although prostitution may not be illegal in the UK, or rather England and Wales here. Running a brothel is. So there doesn't need to be any noise, and so it is an unreasonable use, and furthermore it's actually a criminal act, but there we are. Okay, so for these scenarios, I would like you to look at them carefully, please. You may need to pause the video. Certainly, as you always do, download the copy of this resource. And I would like you, please, to send me your answers for each of these. To just quickly recap, okay, what I want to know is, are those 3 bits there? Is it unreasonable use of the land by the defendant, and so on and so forth from there. And then looking at the criteria. So here you've got a neighbour, a building extension. Scenario 2, you have a sex shop in a local residential area that's just opened. You have in 3 a satellite dish interfering with reception on your television. Number 4, somebody, or rather yourself, deciding to play the violin, but your neighbour hates it. 5, a local authority playground, which is quite noisy. 6, A-level law students celebrating passing their exams and having a legendary party. It's quite noisy as well. 7, poor soundproofing in the walls of your flat mean the noises are even more apparent to your neighbour. And I think 8 is the last one I'd like to ask. So a few more than normal, I know, but I just wanted to cover all the bases. Fumes from a nearby factory damaging your prized rose garden. Once you've done that, and of course please, as I say, email me your answers or take a photograph of your handwritten answers and send them to me via email. You also need to complete this table, please. So defences to private nuisance, there are 3 in particular that are specific just to this type of claim. And the first is prescription, followed by statutory authority, followed by planning permission. And if I switch to the next part, like magic, there we have the definition for each. So you need to know each one, just really a sentence. So prescription is where the defendant can claim if there's been 20 years or more without complaint from the other party, that they've been, the defendant's been doing their thing and there's been no complaint, then essentially it's almost like a form of consent, and so there will be a complete defence there. Statutory authority is only really instances where, as it says, the defendants have, actions are authorised by Parliament. So I'm thinking here, for example, it could be digging up a road, building works, that kind of thing, really. And the last one, planning permission. Again, it's not a complete defence or anything, but planning permission can change the use of a property or an area, and of course, the more planning permissions that there have been that change the use of a place, what I'm trying to get at here is the nature of the locality could change. What might once have been a residential area, if there are suddenly loads of planning permissions put in from people around the area for businesses, for factories, etc., then suddenly it's arguably not a residential area, and maybe that will be something that will stand in favour of the defendant. Again, just a recap, please note this down. Coming to the nuisance, moving to the nuisance is not a defence. Okay, so the defendant, as I just say again, cannot claim, well, hang on a minute, the claimant knew about it, my actions, what I was doing, they've moved there, it's on them. No, the claimant could still win if they succeed with the criteria. So just bear that in mind. I'm going to finish then with an interesting news story, just to try and show this in real life setting. Apologies if I mispronounce any names here. So we've got here banker Savannah's Fuladi, 38, and you can see a picture of her there. Lived with her mother in the property, you can see. And she sued the family who owned and lived above her in this very wealthy apartment. She claimed that the family above treated their apartment like a playground, and so she kept a diary and would say that sleep was affected at night. And as you can see at the bottom, because the floors were not carpeted, she could hear children running and playing, dishes being washed, angry breathing. The family claimed she was overly sensitive, and of course this went to court. So the question becomes, do you think Miss Fuladi in that picture there, who is angry with the family that live above her, do you think she should win her case? And if she does win in nuisance, what remedy should she get? Now, of course, damages, compensation is there. You've also got an injunction, which, as I've been mentioning in the video, simply means you can get a court order that stops the defendant from continuing with that particular activity. Or it could be a type of injunction that decides that particular activity can continue, but only within a specified time or day. So what should she get? Let's have a look. If you're writing down a figure or you have one in mind, now's the time. She won her case and won £107,397, and let's not forget the 37 pence. This would increase, the court said, to an additional £40 a day until work was done to carpet the above floors and basically soundproof the living areas so that she would no longer be disturbed, of course, and her mother. Now, the court obviously felt that some of her claim had been exaggerated. I think the thing that comes to my mind, I don't know about you, was angry breathing. What does angry breathing sound like? I have no idea, but nonetheless, they did accept that this very wealthy property, Kensington, Chelsea, that there had been council officers that had heard themselves excessive and disturbing noise. And you've got the link there from the Express website. Okay, I think that's everything from me at the moment, so I'm going to say thanks very much, everyone, and stay safe. Nearly half term, nearly summer vacation.